Ladies and gentlemen, welcome to another episode of our Property and Finance podcast. Today we've got a very special guest. We have Jared Zak, the founder of Dott Crossitt. Jared, welcome aboard.
Thanks, Theo. Good to be back.
So Dott Crossitt is our conveyancing partner, and for people that were tuned in about a year ago, Jared came on board and talked about sort of all the things that buyers and vendors and landlords and whatnot need to be mindful of. A lot's changed in the finance world. Some changes have happened in the legal world, which I feel like a lot of our buyers aren't too across. So, I want to hand over to you, Jared, and maybe we should just call out some of the changes happened in the last 12 months that you think our buyers, vendors and landlords probably need to be wary of.
Yeah, no, absolutely. Look, there hasn't been that much changes, thankfully, in the conveyancing space. The regulations have had a bit of a sit for a while, which has been good. But there have been some developments we can talk about. I think the big ones are the off-the-plan market and the new build market. There's been some, not so much changes in law, but there's certainly been a change with developers trying to extend sunset dates. And I'll talk about that in a minute. There have been some clarifications around foreign surcharge duty. And if you read the headlines, that's not going away. They love their surcharge duty. Effectively, they've now said that international treaties mean nothing. It's all about raising revenue. And the last one to talk about, I think it's probably good news, is just AI is slowly starting to make its way.
Yeah, the infamous hot topic of AI that's freaking many people out.
Yeah, no, I think it's exciting news for conveyancers, but we'll talk about that in a minute. But
yeah, let's dial back to the first one there.
Yeah, no, the off-the-plan market's interesting. I actually got approached by a journalist the other day. There's been you've heard the building commissioners going on a bit of a rampage, right? Going around and putting works orders on existing buildings and actually putting stop works orders on new buildings.
And that's been happening for a while now, right?
Yeah, at least a year. I'd say there's really been this this sort of new sort of surge of energy amongst the building commissioner.
Yeah, but there was some of it that was probably warranted, right?
Yep.
But now maybe the pendulum has swung too far in the other direction, right?
I don't know. I'm just a humble conveyancer. I can't really comment, but certainly I do hear that. I do hear that he is going a little bit too far, and perhaps that was what was happening in Wollongong. There's a whole lot of these high-rise apartments that haven't been built yet, and the building commissioner has come and said, "Stop work. You're not building things to code. Things are going wrong." Now, of course, they need to get the building right, but the problem with that is sort of mums and dads had put down a deposit to buy a contract off the plan, and they were expecting the property to be built in 2 years. Obviously, their conveyancers and solicitors had probably said, well, factor in 3. But when the building commissioner came in and did this, the vendors, the developers, solicitors, they exercised a clause which is in most off-the-plan contracts to extend the sunset date. Okay.
So can we just explain for the listeners that aren't across the sunset date? Can you explain that?
So a sunset date, firstly, it is not the expected settlement date. So if a developer puts together a plan and he's sort of talking to his sales agents, he'd say, look, everything goes smoothly. We're going to have the property all built in 2 years. Now, the sunset date would not be 2 years. It would be a date with some leeway into it to allow for delays with council, delays with the land registry, just building delays, that kind of thing. So rule of thumb, your sunset date is probably about double your expected date. Okay, and realistically, you probably settle somewhere in between.
It's basically the buffer for developers to allow for just general allowances of delays, right?
100%. And they became more important during COVID because obviously everyone was going through their sunset dates, busting through them. So now, the thing about this, everyone knows about sunset dates, but what they don't always know is that on top of the sunset date, there is now usually in most off-the-plan contracts an ability to extend the sunset date again. And sometimes they give specific reasons why they might be able to extend the sunset date. Sometimes they don't. They just say if anything comes along which is going to put a delay to our project, the sunset date can go forward 12 months, or sometimes it can go indefinitely. And that's what happened with these places down in Wollongong. Because the building commissioner came along and said, you need to stop work, they said, okay, first thing we're going to do is extend the sunset date. For how long? Well, the period in which the work is stopped. Now, the reason why I got approached by this journalist is because they saw the mums and dads said, well, we need our money back. The vendor, the developer, solicitor said, well, no, the money stays as is. We've got to go and deal with this stop works order, and then the project we bat on foot. And they said, well, no, we thought we'd have an apartment to move into in 2025. So the journalist said, well, in these circumstances, what do we do about it? Should the government step in and legislate so that you can't extend sunset dates and all this kind of thing? Now, That just struck me as a little bit of an odd response because there's enough pressures at the moment on the off-the-plan market with builders going under, raw materials being hard to source, probably funding. You probably know about it better than me, but I understand it's quite hard for developers to get funding in that area now. To go in and say, okay, and to basically put more legislation around how long they can extend sunset dates, that's probably only going to be a bad thing for the market.
Yeah. Back to the point of the pendulum swinging too far in the other direction, it's already tough. We've had several guests on this podcast in the past talking about the issues with developers trying to make feasibility stack in New South Wales and Sydney in particular. There's too much red tape. It's between state government and local council. It's already too hard to get things approved. Then trying to have to get things to fit within these guidelines is just going to make it harder. And we're seeing developers go into other states for that reason. So I think these things will only just make it a bit more difficult. And we're at 10-year lows of supply of new housing nationwide. In Sydney, it'd be even worse. So, I don't think that's the best approach. I agree with you there.
I think always be careful.
Can I ask also, there was a long time ago, but I believe this has changed, and it's probably a good thing to just call out. Years ago, I remember with these sunset dates, if the developer felt like the unit value had increased significantly in that long settlement period, they used to deliberately delay past the sunset dates to take the unit back and resell them, right?
Yep.
But they can't do that anymore. Is that right?
100%. Yeah, the famous case, it was Jabima, I think it was. So basically, they'd signed these contracts with long settlement dates, but during that time, the land price would appreciate it massively, and the developers would say, well, actually, we wish that we hadn't actually sold the property for this amount. Well, hang on a minute, we've got a sunset date coming up. Why don't we just sit on our hands and not put that DA in or not appoint that builder, and then we can get the land back. And
they rescind all the contracts.
100%, they got the land back. So it's now illegal to do that. It's actually legislation in the Conveyancing Act. I think it's 66 ZJ or something like that. So you definitely can't do that. But the pendulum has turned now. It's not about developers sitting on their hands and wanting the sunset date to be exercised. Now they actually want it to be pushed out so it can't be exercised. But it's funny how the market changes like that.
Yeah, because on the flip side now, it's the buyers wanting their money back because they're waiting too long for a unit to be completed and they want to move in.
Exactly right.
Yeah. So, that's a good one for people to be wary of. Now, that second sort of change that you highlighted, once again, not many people would know about those duty changes. So do you want to clarify what's going on there?
Yeah, it's been a little bit of a back and forth between revenue and international lawyers. But basically, what was it, probably 5 or 6 years ago, the revenue first brought in, and I talk about New South Wales, but there were similar things in the other states and territories. Pretty much every state and territory tried to do something like this. But in New South Wales, they said that if you are a foreign citizen and you want to buy property in Australia, or even if you are a permanent resident but you haven't been here for more than 200 days, effectively we are going to charge a massive increase on the normal stamp duty. So close to 4 times the normal stamp duty you'd have to pay if you're a foreign citizen. So effectively just closing that market completely. Particularly, I think it was probably focused on Chinese investors it was thought was heating up the market at that time. But obviously it affected all investors. So, and that was very difficult for conveyancers to try and sort of navigate that, particularly the permanent residency rules, because you had to be very, very clear. Well, 200 days before exchange, 200 days before settlement. What was it? What if you popped in and out of the country for business? Really, really difficult for conveyancers who have enough on their plate to try and do that. Coupled with all that, what was it last time? I think when I was with you last time here, an international lawyer actually challenged that legislation and said, well, no, we have double tax treaties in place with all these countries throughout the world. And we have particularly sort of strong ones with countries like, I think it was India, South Africa, certainly New Zealand. And you're effectively treating citizens of those countries differently as if an Australian was trying to buy property in those countries. So that legislation that put in that surcharge duty was actually deemed last year to be unlawful under international law. And there were a whole lot of refunds that had to be done. So I spent late last year processing refunds. Now, about a month ago, the federal government, I assume after being pushed by the states government, have come in and said, no, forget about the international treaties. The state government needs to be able to raise money any way it sees fit. And if they need to do it by discriminating against foreign citizens and permanent residents, they can do that. So the pendulum's now back. Now surcharge duty is back on the table. It's not going anywhere. I mean, the governments, particularly state governments, they rely on handout from the federal government. money's hard to come by for the state governments. They're not going to get rid of the surcharge duty. It's here to stay.
So what does that actually mean? So 4 times the usual duty. Is that what you're saying?
Yeah, that's right. And also land tax as well. They also hit you with a surcharge land tax as well.
There's thresholds for it. Is that right? That sort of kicks in at proportionally different levels, a bit like stamp duty and land tax, I think.
No.
It's consistent amount the whole way through.
Consistent amount. Yeah. There's certainly there's no exemptions for foreign citizens. That's it. So if you
It's funny that you're right. It would be an overwhelming sort of bit of workload for conveyancers and solicitors because so many consumers just don't know this.
Yeah.
You know?
No, it is. And having to explain that to them, you wear many different hats as a conveyancer. Sometimes what you should be doing is focusing on the transfer of legal title, but sometimes you're an immigration lawyer, sometimes you're a disputes resolution lawyer, sometimes you're a family lawyer, sometimes you're a counsellor. So it was actually good that apart from that surcharge change that happened just recently, it's been relatively quiet in the conveyancing front in terms of new regulations, at least in New South Wales. In Queensland, there has been, and there's about to be a big change where they're going to change contracts so there's a lot more disclosure. And that statute has been passed, but it hasn't actually been activated yet. So it's still sitting ready to go. When that changes, that's going to be interesting because up in Queensland, the agents draft the contracts. And they do a pretty good job of it. They've got sort of good admin people set up like that.
Templated contracts, it's not too much to
exactly.
change.
And I just wonder whether those admin departments are going to be able to take it one step further and produce these disclosure documents as they're meant to. At least because don't forget, it's the same thing as New South Wales. The consequences if you don't have one of these disclosure documents will mean that the buyer can pull out of the transaction.
Well, also semi-off topic, but somewhat related, and once again something to probably call out, is this is probably where the necessity of a solicitor as opposed to a conveyancer comes into play, right? So you guys are solicitors and you can give a lot more advice on matters like these rather than a typical conveyancer?
Not necessarily. I'm a solicitor. My wife who works in the company, she's a solicitor, but we've got 10 conveyancers and honestly they are just masters at their craft because all they do is conveyancing.
And a conveyancer can give advice on these matters?
They absolutely can. Where it stops though, irrespective of the state and territory, is when it comes to enforcement of the contract. So that's what you need a solicitor to. So the conveyancers can draft the contract, can interpret it for you, can give you advice on it, but when it comes to actually going to court or some other thing like an arbitration or tribunal, you generally need a solicitor to do that. And you probably also need a solicitor for the step immediately before that, writing those letters saying, look, if you don't do this, if you don't settle now, then these are going to be the consequences.
So the third point that's a hot topic in every industry at the moment, hot topic globally, AI. Naturally in both our industries, people are concerned in finance and in sort of the legal world. AI could replace a lot of the work that needs to be done. But I think, the view towards AI, don't look at it as replacing someone's role. Look at it as complementing that person's role. What are you seeing in your world?
Yeah, it's interesting. It's moving pretty fast. Some of the legal software companies have already developed AI add-ins so that, you can press a button, effectively pre-write an email. So an email sort of distributing a contract or requesting amendments or seeking changes to settlement dates. You can press a button now on some of this software and just have that generated. Some people are developing some contract review software, including my own company, where we're developing an AI sort of scanner of a contract to be able to draw out any red flags. So that's happening as well. But the really interesting one, which I've been a little bit involved with recently, it'd be interesting to know your thoughts, Theo, is dispute resolution. So one of the biggest drags on sort of conveyancers and agents and also mums and dads and people buying property are these little fiddly, we call them micro disputes. So they are disputes in an amount, say less than $1,000 or $2,000. So a meaningful amount, but not so meaningful that you would necessarily want to hold up settlement or have to go to court to have it litigated, right? But they happen almost on every transaction. It's like a 1 in 3, 1 in 4. There'll be something like, you left behind the tiles, or you didn't leave behind the home cinema equipment that we thought was on there, or the grass wasn't grown, it was cut, it should have been. There is a legal answer to them.
But there's a process.
But there's a process, and that process is actually expensive to follow because you've got to appoint lawyers and you've got to put evidence together and put a statement of claim together.
And when it's over sort of minute matters, you start thinking, is it worth it?
100%, that's right. And so myself and a few other colleagues in the industry, we're toying with the idea, and we're probably not here yet, but I think rapidly we will be there soon. We're toying with the idea of actually putting getting pre-agreed sort of prompts together. So basically, the purchaser has 200 words limited that he can put into a ChatGPT or some sort of legal specialist bit of AI software. The vendor can do the same. They might be able to upload photographs if it's a matter about they took this or those holes in the walls or something, and literally just saying to the buyer and the seller in the contract, whatever ChatGPT, whatever AI comes up with in terms of resolution, we're going to be bound by it, we're going to walk away and be done with it, right? So it is a little bit terrifying for solicitors. We actually tried it once, and it got a pretty fair result. It was 50-50. So basically it was $1,000, you get $500, you get $500. But both people were a little bit upset. I thought I got more, but that's pretty much the way that most settlements work out, right? You never get people who are completely happy with it. And sometimes that's the hallmarks of a good deal. In terms of sort of rolling it out to the rest of the market, we're still probably a little bit away from it being accepted. People are still pretty nervous about it, putting things in the hands of AI. But I think we'll be there soon.
Well, when you're talking about transactions of buying property, buying homes and whatnot, which is the biggest transactions that people make in their lifetime, and you make a handful of them in your lifetime as well. You do want to speak to a human being sometimes about that transaction, both from the financing point of view and from the legal point of view. You want to be able to pick up the phone and call someone and say, hey, what about this? What about that? And, get some comfort verbally from a human being, right? Yeah,
that's exactly right. That's been the big thing for conveyancers when people are trying to be the number one conveyancing company in Australia. One of the things that's held them back actually has been, even though everything suggests it could be a digital product, it can't be. Because people still want to, if they're going to be handing over $1 million money into your conveyancer's trust account, they don't want this to be an online company. They want to be able to know, well, where are you? You're down the road, okay, you're behind the estate agents or you're next to the post office. They still have this, there's still an element of a need for a bricks and mortar.
Tangible.
Yep.
Yeah, and it's actually probably a good comparison to what's going on in the finance industry. The online sort of businesses are such that, I guess got some form of digital tool toward offering clients finance online and home loans online. They're only really catering towards the refinance market. So the people that don't have a deadline, don't have the risk of losing a deposit and don't need to ask questions about a potential property they're purchasing to confirm it's, feasible and acceptable security and whatnot. So for the people buying property, they still want the real person.
Yeah, that makes sense.
All right, so dialing back now just for some more sort of general advice, Jared. So let's talk about a few questions that we get asked. One thing I'd love to touch on, obviously, just general advice, tips and tricks, what you're seeing out there, and how to buy at auction and whatnot. But also, the other thing I had here that's a very, very common question that comes up all the time, and it's funny, over the years, people explain this process to people, and then over the years they forget it again. But moving names on and off titles for de facto or married couples, stamp duty implications, what to know about essentially doing exactly that.
Okay, yeah, no, we get that all the time as well. So the first trick to remember is that if you buy at auction, and just say, for example, husband and wife, and the wife buys at auction, but the husband can't be there on auction day.
So one person signs?
So one person signs, one person on the contract. Now, in New South Wales, and I believe in other states and territories, they have an equivalent bit of legislation. You can move the husband onto title before settlement.
As on the transfer.
Yeah. It's called a transfer not in conformity, and I think it's Section 6 under the Duties Act. So there's no double duty. Of course, you can add anyone to title. There's no limitation on that, but it will incur stamp duty, and that's what we're going to try and avoid.
Post-settlement, so once you've actually purchased the property and settled.
Yeah, well, actually, even pre-settlement, if it's not a related party, if you try to move your friend on to the contract before settlement, the New South Wales Office of State Revenue will actually see that as a sub-sale, and they will actually charge you double duty on that.
Really? Is there a qualifying period for that? Sometimes over 90 days or something like that?
No. But there are related persons that it wouldn't relate to, that you wouldn't have to pay stamp duty. So your husband, wife, your de facto partner, your son and daughter, I think your parents. So that's all fine. But if it's someone who you're not related to, if you want to add them onto title, even after exchange and before settlement, that could potentially involve extra stamp duty. Certainly after settlement, absolutely there'll be additional stamp duty.
Wow.
Yep.
So what about...
Unless it's in the context of a family law breakdown, but we can talk about that a bit later.
But what about the other way around? Let's say de facto couple buy a property in joint names and then they get advice from their accountant that it probably suits them to put the asset in one of their names for asset protection reasons. That's completely fine before settlement, right?
It's not clear before settlement. I would prefer, in that situation, and this is sort of my advice generally when you're doing something a little bit funky, would be to actually just terminate the contract and simultaneously enter into a new contract.
But you need to get then the vendor to agree to that, right?
Yep.
And will they? What's their concern?
Probably 3 or 4 years ago, there would probably be a risk that they wouldn't. I think the market generally accepts that. If you sort of cover the legal fees, which are probably about $600 in the redocumentation, I haven't seen, for a few years now, a vendor solicitor say no to that. At the end of the day, they want the deal to go through, and if you can do something without harming your client, so obviously they'll get a 66W and they'll make sure the deposit doesn't leave the agent's trust account, so their clients are protected. But the vast majority of times, they will say that's fine.
So let's talk about, obviously, once you've owned a property for a couple of years, the exemptions that do apply for stamp duty and transferring sort of ownership between names as such. It's basically only for a married or de facto couple. Is that right?
So are we talking about taking a husband and wife off?
Yeah.
So if you're taking a husband and wife off,
or
right,
husband or wife.
your husband or wife off. Okay, the only way you can do that without incurring stamp duty, because don't forget, if the husband comes off, what's actually happening is the wife is buying the husband's share. So that would be a dutiable transaction unless they're separating. So if they're separating under family law and if there's a document to basically support that, then that transaction would be stamp duty exempt. If they're doing it just to protect assets, so for example, the husband's exposed sort of from his own business life and he wants to basically get the property into the wife's name, if they're not separating, that would be a dutiable transaction.
Really? So it's only applicable underneath a separation?
Yeah, 100%.
The exemption?
Yep, 100%. Same thing if you want to move it into a trust or a company. Again, same thing.
The trust or the company, I understand, because that's basically a change of name. But I was under the impression that what happens if sometimes, let's say they buy a property that's a primary residence, de facto couple, because this is also, we're not just talking about husband and wife.
That's correct.
It can be a de facto couple that's separating.
Correct.
Right?
Yep.
Let's say de facto couple or married couple, they bought a property as their family home and then they upsize later down the track and keep that property as an investment, but sometimes for negative gearing or positive gearing reasons, they want to transfer that asset into one of their names. Duties payable.
Definitely. Yeah, definitely duty payable. Yeah. So the only the only other exemption that we haven't spoken about is sort of the opposite of that. If a wife, for example, owns an investment property, that actually wouldn't qualify. If the wife owned the matrimonial property, so the property they live in, their principal place of residence, and they were the 100% owner, now the husband could go on title, stamp duty exempt, providing it's 50-50, right? Joint tenants 50-50, and providing it is their principal place of residence. It doesn't work for different shares. So it doesn't work for 25-75, and it doesn't work for investment properties. That's pretty much the only exemption still available in New South Wales.
So let's put your litigation hat on now, and let's talk about why do you think this comes up here and there for people to put assets in one name as opposed to the other for asset protection reasons?
Oh yeah, well that's so if you're running a business, a small business, large business, if you are exposed to risk of litigation or you're exposed to risk of creditors enforcing on you, then you want to minimise your assets, particularly the places where you live in. So pretty much every businessman client or businesswoman client that I know, they engage with they have some type of asset protection sort of strategy in place, which effectively involves the non-business participating partner owning the real estate.
But it could just be any form of litigation. It doesn't have to be like an owner of a business. I've seen it actually with surgeons. If their insurance doesn't pay, they put their assets in their partner's name for that reason, right?
Yeah, it could be. You've got to draw a line at some point. I mean, I would have thought that, accidents do happen, but if you're working for a company, you've got a salary, you don't have sort of massive investments, or you're not an extremely dangerous driver on the road, then there's probably no need to sort of embark on some sort of elaborate asset protection strategy because it costs money. A lot of the time it costs stamp duty is actually the nub of it. So yeah, but if you own your own business, if you're at risk of being sued, or if you're borrowing a lot of money personally in your own name for other investments, yes, definitely definitely consider some asset protection that would involve putting real estate in your non-participating partner's name only.
Now, we're going to be dabbling in family law here with my next question, but that wouldn't change, let's God forbid, I should say, that if a married or de facto couple is going through a separation, that wouldn't change the entitlement of what either party was getting out of a separation or a divorce.
Yeah, that's a good question, and that's the reluctance. A lot of the time, people say, "Well, I don't want to put the property in my wife's name only or my husband's name because that's it. I won't. If something happens down the road,
then it's theirs."
That's not how it works.
Yeah, it doesn't matter what name assets are in. If you're living together, especially in the family home together, everything's up for consideration.
Yeah, everything's up for around 50-50. That's pretty much, despite what you might hear sort of at the pub, it's all about 50-50. The assets get distributed, except if there's children and one partner aren't working, those splits can sort of change.
Because of custody.
It can sort of blow out to maybe 70-30 or 60-40, but 50-50 is the starting. It's the starting point. So if the couple only owns one property and it's just in the wife's name, it may be 100% in the wife's name, but it's 50-50 at law.
That's a good shout once again, because sometimes I feel like also the family lawyers are starting off on each party's aggressive stance to try and sort of spark an argument for as long as possible, right?
Oh, sure. They'll try and argue, that was that was meant to be her or his asset only, but it's only posturing. As a matter of family law, it doesn't matter whose name is legally on title.
Yeah. All right. That's a good wrap on that. Let's bring it back down to how to buy at auction, things to know, tips and tricks, like I sort of touched on that we would talk about. There's a few red flags you see with day-to-day contracts you review. What's your best advice to all our listeners out there on auction conditions? Interstate conditions is a big one.
Yep. Well, let me tell you, I think I put this on my Instagram the other day. I don't know if you saw it, but I had a client had an absolute shocker the other day. Normally gets their contract reviewed every time, but there was an auction and he just sort of thought, I won't bother getting this one reviewed because they're all pretty straightforward, are they? There's not going to be anything in it. Didn't get his contract reviewed, won at auction, submitted us the signed contract on Monday. And unfortunately, in this particular contract, we're talking before about surcharge duty. There was an adjustment in that contract that said the buyer must pay the vendor's surcharge duty of land tax that he has on that property at settlement. So he'd accrued, because he was a foreigner and he'd owned the property, he'd accrued a big land tax bill, and it was basically 4 times the normal land tax bill because he was a foreigner. He hadn't paid it that year, and he had a clause in the contract that said the buyer has to pay it. It amounted to $38,000.
Because is that aside from the fact that it was a surcharge duty, the contracts sometimes do commonly have land tax is passed on, and the surcharge duty fits within that definition, right?
Well, no, that doesn't fit. No, there was actually a nasty little clause in the contract.
Oh, that's specifically outlined it. So they knew it was coming.
So it's a good point. So land tax adjustments are reasonably common. They're not nice either, but they're not $38,000 most of the time. They're probably an average land tax adjustment, depending on when you settle. But this time of year, if we settle this time of year, it's probably going to be about $3,000, $4,000 for your average house in Sydney. But on this particular property, it was a factor of that because they put a clause in there that said not only do you have to pay the normal land tax, you have to pay the actual surcharge land tax.
Wow.
So this was a shocker, and it was very easy to spot this clause. It all could have been resolved if he just had it reviewed before the auction.
Yeah, wow.
So, yeah, that was a shocker, that one.
So what else? Interstate conditions, what to look out for, what's some other sort of tips and tricks from Dott Crossitt?
Yeah, well, look, staying with auctions for a little minute, so definitely get your contracts reviewed. Try and give it, I think, you don't want to go too early necessarily, and you don't want to, but you definitely don't want the property to be sold without your knowledge. So what we are seeing a lot now at the moment is a property set for auction next Saturday, but vendors are now accepting offers prior to that. And I have had a few clients who have sort of sat back, we won't get the contract reviewed until sort of the Thursday or the Friday ahead of the auction. And because they hadn't registered an interest with the agent assumed that they weren't really going to be contesting the property, and they sold it to someone else.
Because even though you might be speaking to the agent and you seem somewhat interested, the real indication of interest is when they've engaged their solicitor who's potentially reached out to the vendor solicitor for some contract changes.
100%. I mean, you talk to agents probably more than me, but my understanding is that, conversations are pretty cheap. What really matters when they're assessing the relative interest in the property, it is who has downloaded the pest and building inspection. They can see that on their website. They can see someone's downloaded, particularly if they've paid some money for it. That means that they're very interested because they're going to put their money where their mouth is, and whether they've actually had a contract reviewed. And again, they've got access to that information. But again, it means that the buyer is really, really interested because they've spent a little money to spend a little bit of time to try and do their due diligence. So yeah, I think it's a little bit. You don't want to be spending $500, $600 on every single property that you flick on Domain and think might be interesting, but you also don't want to leave it too late, otherwise you're going to miss out.
And so the properties that you're seriously looking at making an offer on, basically, you've been through them, you're interested, and you want to stay in the mix, but you're hoping to go to auction to see where it lands. They're the ones have it reviewed. Don't wait till auction because you might miss out.
Yeah, and maybe don't try to play it too cool with the agent, particularly if it's going to auction, because it doesn't really matter. I mean, if you are interested in a property, let them know, because these sort of Dutch auctions that are happening 2 or 3 days ahead of auction, we're seeing them actually almost happen more often than the actual auction themselves.
And that's a good, another great shout. Sorry if I keep saying that on this podcast, but there's been a few really great call-outs there. The current climate right now, it's been up and down throughout the past sort of year or two. We've had cycles of where it's been really hot, and as soon as a property comes to market, they've got contracts out to 5-6 parties and offers being made straight away. But I think we're going back into a bit of a soft sort of cooler market, you could say, at the moment, where I think everybody was anticipating that rates were going to come down soon, and now it's quite clear with the most recent unemployment data and inflation data that that's probably not happening anytime soon. It's looking like the interest rate's probably going to come down early next year. January, February is now what the general forecast is, which means I feel that a lot of buyers have checked out and they've said, now we'll put our house hunting on hold because they're not comfortable with the current interest rate environment and whatnot. And so tying that back to what you were talking about with auctions and making offers, generally if an agent only has 1 or 2 serious contract holders or serious buyers, I should say, they will sell the property prior to auction, right?
Yep.
So in a hot market, they'll go to auction, let 5-6 bidders bid it out. But in a sort of weaker market, it's quite the opposite. 1 or 2 people will probably snap it up just before auction, and to your point, it could just be literally a few days or a week before.
Yep. And so, and we're starting to see that. Definitely what you say chimes with us. About a year ago, because don't forget, we act for the vendors, right, on 50% of our deals, and we do about 3,000 deals a year. And Fridays before an auction for us are like hell. They were last year, because particularly the ones that might have been underquoted a little bit, which was and still is a bit of a thing, we would get 10, 12, 13 requests for amendments. We'd all have to deal on a Friday afternoon. Now, what I can tell you, you still get the odd deal like this, but nowhere near as many. We're seeing probably on average for auctions, we're probably seeing maybe two or three sets of amendment requests.
So, oh wow! So that's a clear indication of what's going out there in the market. So last year, probably 10 to 12 serious bidders on a property.
Yep.
Now it's 2 to 3.
Yep. That makes it easier for us because
it's a relief for you, but sometimes not the best outcome for the vendor, right?
That's right.
On that note, we were talking about the start of this year, record volume, right? The start of this year, which is directly correlated to listings and how much stock we saw. You still seeing that?
Well, yeah. Just to reflect on that, we had February for us is normally the quietest month. We all go on holidays. Everyone takes their annual leave. It's really quiet because February for settlements normally relates to exchanges that have happened around the Christmas period, which is really quiet because everyone's sort of holidaying and shut down for the year. we had a record February, and it wasn't just me; it was a number of my other sort of competitor firms as well. So I don't really know what happened towards the end of last year. Maybe you've got a better idea than me, but it was just very unusual for us.
Yeah, well, same thing. Back to the point about the market just being up and down constantly the last sort of 12 months. It was a hot market last year, once again, because people were anticipating rates were going to come down the start of this year, right up until October when the US Fed came out and said that they're probably going to increase rates another time. Then we had a rate increase in November, and that last quarter, the tail end of last year, people just checked out. Buyers were just not making offers once again, waiting until this year. And then the start of this year, the forecast on rates went the other way. We're going to have rate cuts soon. The consumer spending data for the last quarter of last year was weak, and it looked like they need to stimulate the economy soon. And it's changed again recently. So hence why it's been hot and cold, quite patchy, basically because buyers are very acute and aware of the ever-changing forecast of interest rates, and they're reactive to it. They do think that it's not just also they're making this decision based on their affordability and current, like to my comment before about current landscape. It's not about, repayments for the next 12 months. It's because they're all trying to chase value. And they feel that if rates are going to stay this high for another year, maybe there'll be better value in 6 months' time. My personal opinion to all that is that don't try and look for, the right time to buy. Don't try and be an economist and forecast, the optimal conditions to buy in, what's going to happen in 3 months' time or 6 months' time. Even all the major bank economists can't get that right? They're changing their forecast on interest rates every 3-4 weeks. The hardest thing to do for a buyer is find a property that they actually want to buy. And that, I think, is more important. Set a budget and a cap on what you're willing to pay for that property when you do find something that you want to buy, and just execute in that market. And I think that when you are transacting multiple properties, or when you're upsizing and you're having to buy and sell, I think it's also quite crucial to buy and sell in that same market. Try and do it in a sort of 3-4 month window. Selling and then staying out of the market for too long can mean the market runs without you. And then buying and going to a bridging situation of selling also has sometimes some risks,
Yeah, I'd agree with that. I do get a lot of clients who almost see the property market as being something akin to trading in the stock market. And they feel like it would be the greatest tragedy that ever happened to them if they bought a property and it went down in price for the next year. But you shouldn't think like that. Just worry about the individual property. Worry whether you can afford the repayments. Worry if the strata report is clean, whether the pest and building is clean. Just worry about what settlement date you have, and don't put yourself under too much financial pressure. Worry about what you can control. Not the market, because you say, not even the experts can pick whether property is going to go up or down in the next 12 months. But over the long term, it always goes up, right? So, that's been the experience thus far. So, yeah, definitely try not to overthink it. Focus on, the details of your proposed transaction and whether you actually want to live in the property you're going to buy.
Because even if the market goes down in the short term, 12 months, let's say, you're only going to, be privy to that downturn if you recognise the loss by selling your property. So you just got to ride things like that out, right?
Yep. I think that's good advice.
So let's go back to some advice for our clients. One thing I want to touch on, we did, I think, touch on it last podcast, but I want to touch on it again. It's a common one that comes up, just around the deposit clauses. So some people reduce the deposit. Most people reduce their deposit, I feel, these days from a 10% deposit to a 5% deposit. Are there risks with that? And the other one is releasing the deposit to the vendor in the settlement period. Advice on those?
Yeah, so definitely, with prices so high, it's almost becoming standard for buyers to say, well, let's pay a 5% deposit. And a 5% deposit is often a very meaningful sum of money. And often people have a lot of their cash tied up in other property, really, so that they don't have ready access to a 10% cash deposit. So we'd probably see 60% of transactions we do would have a 5% deposit. Now, what you will often see if you're a vendor, and you'll see it as well as a purchaser, you see this clause that they put in the contracts these days, particularly in New South Wales, that says, notwithstanding the purchaser is going to put down a 5% cash deposit on exchange, in fact, it's a 10% deposit. and you will owe the vendor the additional 5% if you default under the transaction. So that's like a magic wand where you can say, well, fantastic, I've only got 5%, but the vendor wins as well because it's actually 10%. Well, my advice is it doesn't really work like that. So from a vendor's perspective, for example, if you only get 5% cash in the agent's trust account and the buyer goes walkabout, he goes missing, he dies, he goes into debt, he divorces, he defaults, right? How are you going to get the other 5% that you've got this magic clause for?
Yeah,
right?
you've got to go to litigation.
You've got to go to litigation. And if he's busted broke, well, guess what? And he probably is if he can't complete the transaction, get it. So they often say, possession is 9/10 of the law. This is the case with deposits. Yes, you can put a fancy clause in there. In fact, I would always recommend having that clause in there as a,
because that clause is not standard.
No, it's not. It's not standard. It's becoming more and more common. But don't think it's a silver bullet, because particularly if you've got another property that you were going to purchase on. So we've had these nightmare scenarios, Theo, where our vendor client has
committed to something else.
And he's paid a 10% deposit because he's sort of been a bit blasé about it, but he's only received a 5% deposit because he's thought, oh, well, 5 means 10 will all be okay. But when his buyer has defaulted, he's liable to pay his 10, and the 10's sitting in the trust account, right? That's going to go, and you're only going to get 5, so you're out. So the golden rule with that is, whether it's 5 or whether it's 10, make sure it's the same, or at least the same, when you're sort of buying and selling simultaneously.
We might have also touched on this last time, but I just want to call it out again. That's why you also don't mind deposit bonds, because if this situation happens and someone's given a deposit bond, it's paid within like 48 hours, right?
Yeah, I like deposit bonds for that reason. So they look, they're not free. I think they're a couple of grand cost up front, but they give you peace of mind, particularly if you're a vendor, because you don't have to go to litigation to try and get that deposit back. You can just wander on down to the insurer, the deposit bond insurer, hand in the piece of paper, you can get the money. And if you have committed to another transaction, you will be able to, you might not be completely out of jail, but you'll be able to mitigate some of your losses. You could probably say to the vendor, look, here's the deposit now. Can you give me some extra time? I can go get some bridging finance or something like that. So, yeah, I really like deposit bonds. The other reason why I like deposit bonds as well, Theo, I don't know whether we spoke about this last time, but I still think the easiest way to lose money in a conveyancing transaction these days, it's not picking the market wrong, it's not a land tax adjustment, it's actually cyber fraud. The amount of times that we have had clients lose money when they're transferring deposits from agents here and there, right? It happens all the time. We're getting hit almost every day with scammers.
Yeah,
at least with a deposit bond, well, that's sort of outside of the cash system. It's a piece of paper. It's going back to the old, the old sort of check day. So
it's really common these days. We've seen quite a lot of it. I think you've seen even more than we have. So let's just highlight what you're actually referring to there. Someone intercepts the payment details essentially for the deposit to be paid or for settlement arrangements?
Yeah, there's different ways to do it. The most common one is this, Theo. I'll give you actually a real life example from someone. Actually, I think you know the person, a mutual friend of ours, very, very intelligent. So you're not the kind of guy that you'd think would be caught out by this. I was reviewing a contract for him, and he got an email from the agent. And this was not like sort of Theo Chambers at Outlook.com. This was an actual email address from the proper agency. It had the proper suffix at the end, right? And it said, "Oh, look, I noticed that your cooling off period is going to expire on Friday. It was Monday. Could you just pay me the 10% deposit now, just so we can have all our ducks in a row?" He thought that was a bit of a strange request from the outset. Oh, wouldn't I just pay the 10% deposit when we actually cool off? But it came from the email address of the agent. So he paid the 10% deposit. He didn't even mention it to me, unfortunately. Just paid it, and then come Friday, when we're about to cool off, I said, "All right, time to pay your 10% deposit." And the agent, meanwhile, had also called him up and said, "Time to pay your 10% deposit." He said, "What are you talking about? I paid that early on Monday, like you asked." Turned out that someone had hacked into the agent's email address. So he'd got that, and he was sending, and he'd basically gone through, and they've obviously got some conveyancing property market sort of experience. They can work out, they even know what cooling off periods are, and they can calculate deposits, right? And he's gone through and he's worked out, he's probably emailed a few people, but he's emailed my client, and all the details were correct, except, of course, the trust account details that they were his bank accounts. That as soon as it's transferred in there, it gets transferred and transferred and transferred and transferred and sent out of the country. So I don't know exactly what's happening. I think there's might even be some litigation with my client and the agent on that one. Because I think my client's probably saying that there was a duty of care to have better cyber systems in place, so they didn't receive that email.
Which is true. They should have two-factor authentication and whatnot if someone's logging into a new email address.
But that was a more sophisticated one. The average one is probably more of like a dummied up email address. So it'll sort of say, John Smith Ray White at gmail.com.
Yeah.
And if you're rushing,
it's a lookalike.
It's a lookalike, exactly. It's a lookalike. Yeah. And those ones, we probably get those ones almost every day.
Yeah, I've seen a lot of them.
Yeah, and there's now things you can do where you often have some alerts. We'll often say this looks like an email address, but it's not. But that one that happened to our friend of ours, that's almost impossible to. It's not impossible.
I haven't seen too many of the actual email addresses. You're right, because they have to hack the actual individual's email address. But yeah, I think it's called phishing when it's a lookalike, right? And we've been seeing a lot of it over the years. It's definitely improved and they've become more and more sophisticated. It's interesting. They've I guess, progressed in their careers as scammers because they used to target just repayments, right? So the one thing that we used to see all the time was they would somehow figure out where the person is up to in their buying cycle, and as in like they've purchased a property and the settlement's coming up, and they would do the lookalike email address and email pretending that they were us, representing the broker, saying, okay, leading up to settlement, can you please transfer your first month's deposit, first month's repayment? It used to get done quite often.
Wouldn't they also be the contribution, like the non-bank lending part? That'd be a much bigger amount. Did they ever?
No, we only just saw. I think it was easy for them to get away with the first month's repayment.
Yeah. Okay.
No, I haven't seen the deposit is now what they've sort of progressed into, which is what you're seeing, and we've seen a handful of it. But I think businesses are now becoming more and more aware, and so are consumers, and they are sort of making sure that, for example, something as simple like we said, two-factor authentication will stop someone's email from getting hacked.
Or phone calls.
And phone calls,
and that goes back to the point before you said about digital sort of companies now are probably seen as more vulnerable to this kind of thing. If you can have a phone call with your broker or a phone call with your conveyancer and ask, hey, did you just ask me for an amount to be sent to my... Yeah, you did. Can we just go through the bank account details? Okay, fantastic. Those conversations, that will save you a lot of money.
So one more thing on that, back on the deposits that we were talking about there. We said 5-10%. They're the things to look out for. Something that keeps appearing on our Google searches on our blog posts, which we've done. We did touch on last time, but just once again to rehash things to look out for with the release of deposit clause.
Yeah. So release a deposit, if you're buying a property, it is a clause that says that the vendor can actually get early access to the 5 or the 10% deposit that they've put down in the trust account of the agent, and they can in turn use that. Most of the time that the use is limited to buying another property. In fact, I would say it should always be limited to that. So you might think, well, why would they want to do that? Well, again, it goes back to what I said before, is that cash is hard to come by these days. Not everyone has a 10% deposit lying around. Most of their equity is actually tied up in property. So you can kind of see financially, you can kind of see why it makes sense, but most solicitors, particularly traditional ones, do not like it because I guess they just come back from the principle, well, we shouldn't be parting with any money until we've actually settled. Now, there are situations where clients can lose money, and I have had a client before lose money where they agreed to have a deposit released for a vendor. Now, it was a very, very long settlement date. That's your first red flag. If you have long settlement dates, probably reconsider a release of deposit clause. But this vendor took this money, and when he bought this property down the south coast, and he actually defaulted on it, and the vendor in that transaction took his money, which was our money. And then when we came to settle our transaction, we couldn't settle because he had a cast of thousands of banks and caveators and creditors all chasing him. And we were just sitting there waiting for him to settle, and he couldn't because the creditors wouldn't release the mortgages. And we said, okay, well, give us our money back. And he said, well, I actually lost it.
Yeah.
So that was sort of a 1 in a 3,000, 4,000 type event.
But still, there are risks. Is the highlight there.
100% it does happen. So.
All right, well, just the last thing to wrap up this session today, once again, we touched on it before, interstate sort of differences on contracts people need to be mindful for. So I feel like one thing that's definitely taking off online at the moment is this buying an investment property in other markets because let's say some people can't afford to buy their first property in Sydney, for example, a home. They might look to accrue some wealth by buying an investment property in somewhere like Brisbane's a hot topic, WA, Perth is a hot topic. With those markets, there's different conditions, right? So what to look out for?
Yeah. So, yeah, firstly, we've definitely seen that. I mean, Western Australia right now is just absolutely going gangbusters for us. You know, it's probably almost 5% or even, maybe even 10% of our clients are now buying and selling in WA, particularly buying. Now, the thing you have to, so as you touched on, every state and territory actually has different property laws, which makes it very, very difficult. And you might get used to the idea of a 5 business day cooling off period in New South Wales. That might have been what your broker told you. That might have been what happened last time. Well, guess what? There's no cooling off period in WA, right? In Victoria, it's a 3 business day cooling off period, right? So,
and just the general settlement periods also vary, like the usual settlement period that you would accept and things like that.
Yeah. So you'd probably say New South Wales, the average settlement date is 42 days. Queensland, it's probably closer to 30. And then it's weird in WA where they actually don't have a set settlement date most of the time. They have, it's a period set from when you get your finance approval. So it's kind of a moving settlement date, which must make it so difficult for vendors to basically forward plan, but that's just the way the market works. In other words, you buy a property, you've got 21 days to secure finance in WA. That's a very rare thing in New South Wales, as you'd know, but in WA, it's almost every property. And then what the settlement date will be defined as 30 days after the period in which you get your finance approval. So moving one, yeah.
All right. Well, that's been fantastic, Jared. Thank you so much for coming on board. If anybody wants to reach out to Dott Crossitt and Jared's team for any advice, thinking of potentially selling or buying, or just general property advice related to Dott Crossitt's business, please don't hesitate to go on our website. It's under our partners page. You can click on a link to Dott Crossitt or go obviously directly to the Dott Crossitt website. I should have said at the start of this podcast, Jared is in most states now, I believe.
All states and territories, yeah.
All states and territories, so operating nationwide. So you can find a local provider very easily. Jared, thank you so much for coming on board. Appreciate your time.
Thank you, mate.